Good evening, everyone. Welcome to Overtime. An extraordinary amicus brief has been filed today. No, sorry, it was filed 2 days ago. We're looking at the docket now. It's stunning. It's extraordinarily well written and argued. And if it's accepted, will almost certainly trigger a constitutional crisis, the likes of which we have never seen in the judiciary before. There are ways a corrupt Supreme Court could get out of this crisis, so who knows? But this is an absolutely extraordinary document. It was filed in J.G.G. versus Trump. Now, many of you may not have heard of that before or know what that is. You've all heard of it in one way or another. It is the central thrust of the ACLU and a number of other organizations. And it's the ACLU, but vis-a-vis full disclosure, I am a card-carrying member of the ACLU. I've shown the card. I'm proudly a member, have been since 2004. I know that there's been some concerns. There was a period there where they were doing some pretty unacceptable things. But having said that, they are our best defense against what we're seeing today. The ACLU filed the original attempt to stop the deportations based on the Alien Enemies Act. All of that is rolled into J.G.G. versus Trump. The current contempt hearing against Kristi Noem is part of the J.G.G. versus Trump. What you see right now, and I know the left-hand side is cut off, I apologize, but this is the J.G.G. versus Trump docket. You can see the initial filing, complaints and summons against basically everyone from Immigration, ICE, Department of Homeland Security, so on and so forth. And this goes all the way back to March. This is the Brego Garcia falls under this, and this is a huge docket. I have never seen one this big. This is actually 2 pages on the docket on Court Listener. I'm sure there are ones that are more, but it's been going on for a while, and it's all the shenanigans. All the appeals are on this docket. This covers the entire issue. Now, it is what's called a class action. It became a class action lawsuit. So essentially, the U.S. Supreme Court said that when in this exact case, it was decided that there would be an injunction against deporting anyone until they could have their due, and it's just a nationwide injunction by a judge in D.C. The Supreme Court said, no, we're not going to let a single judge in D.C. do a nationwide injunction. So they decided to basically make it a class action suit. Now, what a class action is an action on behalf of a group of people, and it can be any group you want. They call it a class. The reason they call it a class, a group implies maybe membership, you've signed up, something like that. Class action, everybody's a part of an infinite number of classes. You can make any class you want. There was a recent case where a class was set, all women employees who had ever worked at Walmart, currently working at or ever had worked at Walmart. All people with blue eyes is a class, any class you want. All people with blue eyes whose first name begin with Q. That's a class. In order to have a class action suit and to have any impact on a class, you have to define the class. You have to get it approved by the court. This is where the class is defined. That was March 15th. The class was defined as all non-citizens of the U.S. in U.S. custody who are subject to the presidential memorandum, the evocation of the Alien Enemies Act regarding to, so that's the class. It's a pretty specific class. Trump was enjoined from, or the government was enjoined from removing anyone who fits in that class. So that's sort of the same way as doing it. It just takes a little longer and is harder, but once again, boom, you've done essentially a nationwide ban on a particular activity by making it a class action suit. So there were numerous appeals And most of those appeals lost, and then it went to the Supreme Court. At the Supreme Court level, most of those appeals won. Those were appeals of temporary restraining orders and the like. So a lot of what's here is temporary restraining order against removing people, temporary restraining order against yada, yada, yada. And notices of appeals of that by the U.S. government, notices that the appeals lost, notice of a second appeal to the Supreme Court, and then notice that the appeal won. So that's what most of this is. You'll see the occasional amicus brief. What is an amicus brief? An amicus brief is basically means friend of the court. It is somebody who is filing who is not a direct participant, but for some reason believes that they have information that would benefit the court in one way or another, and are filing so that the court can hear whatever they have to say. When a man put up a fake police website mocking his local police department, and the police sued him, it got to the Supreme Court, and The Onion, the satirical fake newspaper, published what is still considered one of the most brilliant amicus briefs ever. It is available on our website. It's also available on our Discord. But the entire amicus brief was mocking the U.S. Supreme Court and then pointing out that mocking is a way of not only freedom of expression, but a way to express dissatisfaction that can't always be done seriously. Sometimes by making a joke, you can approach topics that are too taboo or dangerous to approach in other ways. And then after making that point, would mock the Supreme Court even more right in this brief, sometimes in Latin, sometimes not. So that's what an amicus brief is. This goes on for quite some time. More depositions, memorandums, injunctions, and this is what we've been seeing in the news since March. I mean, this is this includes leave to file amicus brief by Megyn Kelly. So in May, Megyn Kelly filed an amicus brief with the court. She's going to be important in just a second. Also motions for anonymity. Some people wanted to participate anonymously, so motions for that. This is just insane. More appeals, motion for a stay, a proposed order. Oh, dear Lord. And then we get to December 10th, leave to file amicus brief by Megyn Kelly. This is her second brief, and you don't normally get two amicus briefs. There's no point. You should have covered it in the first. So this was filed 2 days ago, and the court can decide whether or not it's going to hear it. Now, let's assume that they've decided to accept the brief and that they will consider it. They may accept it, but it may have no impact on their decision in the end. And they will say later, we considered the points of this amicus brief, but ignored it, yada, whatever they want to say. So as of yet, we do not know if they have accepted the brief or not. The docket goes all the way up to today. It's up to the minute. And as of this minute, let's see, I think reconsideration of I don't know. I'm not even going to get into it. So what did she say in her amicus brief? Wow. She essentially said that Donald J. Trump, this is a brief, Donald J. Trump and his administration and his supporters have been systematically threatening, intimidating, and otherwise coercing district, state, federal, and Supreme Court judges to rule in their favor. She is essentially impugning the entire judicial system as being under direct threat, not just implied, but actual threats from Donald J. Trump, that this has been influencing their decisions, that their decisions have been unfairly in his favor, and that this has denied anybody who's been in front of any of these judges, potentially any judge in the U.S., due process if they have been opposed by Donald J. Trump. It is a staggering allegation to make. It's a staggering one to put into an amicus brief to submit, and it has huge ramifications. Now, the first thing I'm going to say is I have no doubt she's right. I have no doubt she's right. I hadn't considered that somebody would just call him out on it and put it into a brief, but this already has, at a minimum, one constitutional crisis built right into it, and a potential for a second right after that. The first is it's almost unfalsifiable. I completely, she's right. Nobody who's been watching anything over the last year can say that she's absolutely correct. But Socrates, when he was on trial for corrupting the youth of Athens, the prosecutor said that Socrates could make the best arguments of any person ever to have lived. In fact, he's so good that he might even start to convince some of you he's innocent. So if you start to believe that he's innocent, that proves he's guilty. That's an interesting argument, and it's unfalsifiable. It's unfalsifiable. There's no way to get around that argument. It's obviously hogwash, but there's no way to get around it. Now, what she's saying is anybody who's ruled in favor of Trump, there is a decent likelihood that they have been coerced in some way. Well, if you agree with her, fine. If you disagree with her, well, you've been coerced by Trump. So there's already built into this a problem with the argument, despite the fact I agree with it. And it's one that the judge is going to see and be aware of. The Socrates argument is one of the first things you learn in law. It's an unfalsifiable art. It's a problem. The way she writes this tries to get around that, and we're going to discuss that. She tries to, as clearly as possible, limit the scope that she's making this accusation to very specific cases and ones in which she can present evidence for, and she does in this brief. So this brief has a real shot of overcoming that problem, but that is the first problem. It's so sweeping as to almost invalidate itself. Having said that, there's a second problem. Let's assume it gets accepted. Let's assume that the judge says, you know what, you're right, which she is, and invalidates any of the previous Supreme Court. This could be used as an attack on every one of the previous Supreme Court decisions, possibly going back through the Biden administration to Trump's first administration. That's how broad and sweeping this could be interpreted and be used for. Okay, let's say you disagree, and cases start getting overturned and you disagree. What are you going to do? You have a right to appeal. You have two options. You could appeal to the D.C. District Court or to the Supreme Court of the United States. Now, if you appeal to the D.C. District Court and you don't like their decision, then it's the Supreme Court of the United States. So either way, boom, you get up to the Supreme Court of the United States. She directly implicates the Supreme Court of the United States, starting with Justice Alito, as having been directly influenced and threatened by Donald Trump. meaning the Supreme Court of the United States, because she's questioning the validity of their decisions and saying that they have been impeached, and I'm using this now in the legal sense, which their credibility is gone. By arguing that they've been impeached, they can't hear the case, which means you have no recourse to challenge this. But you're entitled to a recourse to challenge this by the due process clause. But you can't. Okay, so we shouldn't hear this, except that she's right and she's got a valid point and she's got a right to submit this and be heard. Damn. So, if you don't hear this, there is a potential constitutional crisis and you are ignoring an existential threat to the judiciary. If you do hear this, you are creating a constitutional crisis and an existential threat to the judiciary. This is stunning. And once again, I find myself in the position of saying, I have no idea why mainstream media isn't covering this, other than, yeah, it does require some nuance, which is, thank God, or I wouldn't have a job. Let's get into what she says. This is her brief. Table of citations. Letter from Congress to Justice Alito, pressuring him to pass a code of conduct based in part on his wife's alleged conduct in the 2016 insurrection. I had forgotten about this. But she's right. And notice the date. This goes back, this is why I said before, she's attacking the judiciary since before his current administration. And based on Trump's previous administration. So if this is not only successful in that it's submitted, the court accepts it, but if the court in any way whatsoever accepts the value of any of these arguments, it is a precedent to undermine every decision, including the Roe v. Wade overturning, including all of it. It sets a precedent to undermine that, with the caveat that any attempt to undermine that must have some form of recourse, and there is none because it's the Supreme Court that's being impeached in this document. Oh dear. Letter Alito recusing himself. Okay. CBS News. Walmart lays off employees. So a lot of these are Florida's controversial free kill law. How does it, how it denies justice in medical malpractice, wrongful deaths. She also cites, ramps up attack on judges, floats eliminating federal courts. Okay, so one of the arguments she's going to make is that the House has also been threatening, and the House, again, here in this case, being an arm, is what she's going to argue of the Trump administration, Johnson acting in on that behalf, following court rules that have halted Trump's agenda. Private prisons. The one I'm looking for, I'd seen earlier, was about Alito getting threats, death threats, for having a flag, and the idea that the number of death threats against all judges in this country have gone up, which they have, which this judge knows. So she is actually, one way or another, sending this to a receptive audience because the judge who's hearing this knows she's telling the truth, because he's been part of this case going back since March and watching it happen. The very cases she's talking about go right back to the overturning or the stay of the injunctions against tossing anybody from the United States. This is stunning. All right. I, Megan Kelly, Esquire, humbly and respectfully, let me move this just a little bit. Submit this amicus brief in support of neither party to present arguments neither party asserted to prevent the dissolution of this United States. Okay, that's a bold claim right there. I am submitting this because I think the United States is about to collapse, and that's why I'm submitting it. Although my arguments are unfavorable to the defendants, no shit. Really? The defendants being Trump. Okay. Plaintiffs have no position. Yeah, I doubt that. I'm sorry. Just wow. Defendants counsel did not respond for a stance back. I'm surprised. You'd have think they'd have gotten the press secretary to start hurling death threats. Argument. Interest in this case with objective to preserve. This does show signs of being hastily written. Issues of fact, record of the court to stress to have discretion to consider uninhibited by government forces. Okay, yes. So her interest here, she says, is to preserve essentially due process and to have it not be inhibited by force or threats, and make sure that where Article 3 of the Constitution gives courts certain powers, those courts retain those powers. It's ironic that we're discussing this because Donald Trump just pardoned, let's see if I can find her name. I don't have it handy. Oh, yep. Just pardoned Tina Peters. Now, Tina Peters was the one who gave the MyPillow guy the election data in Colorado illegally. She was found guilty of election tampering and a number of other crimes and put in jail in Colorado after being tried by Colorado citizens, a jury of her peers. Donald Trump has said that all she did was try to make sure that the election was fair and issued her a pardon yesterday. Here's the problem. He can only pardon for federal crimes because he's the head executive, chief executive, or for D.C. because D.C. doesn't have a governor, so it defaults to the president of the United States. Governors pardon state crimes. So if you commit a crime in Colorado, your governor can pardon you in Colorado, but nobody else can. The president cannot pardon crimes in Colorado. Nonetheless, President Trump has issued her a pardon. She is now demanding to be released, and MAGA is descending on the prison, saying that she should be released because she's not guilty. She's been pardoned by the president. Well, he has pardoned her, but she hadn't committed a crime, so it doesn't really matter, at least not at the federal level, the only level over which he's got jurisdiction. This is yet another power grab, and if Colorado caves, as I'm sure they're aware, it sets another precedent. Colorado's essentially saying, okay, yeah, Trump is king. He can pardon local crimes now. He can pardon in areas where he doesn't have jurisdiction. She didn't break, she did, but she wasn't tried or convicted on federal crimes. That's not what's at issue. It's state crimes. She was tried by members of the state following the state process in where she lives and was found guilty by a jury of her peers. That's why Trump can't pardon himself for the 34 crimes that he's been convicted of, the 34 felonies. It's because they're all in New York. He's got no jurisdiction in New York. So the argument that is being made in this amicus brief is that the courts should retain their jurisdiction despite significant influence by the executive and possibly the legislative. I'm in a unique position and have special knowledge to present issues that apply to this case and court and the parties to preserve the rule of law. Other parties and their counsel are attacked for restraining President Trump within the purview of the constitutional limits. U.S. attorney generals are sitting beholden to Trump to secure seats as not yet nominated and confirmed. The AGs face additional retaliation should defendant clients disagree with AGs, even if the AGs are acting in the best interests of their clients, including defendant Donald Trump. What she's talking about here is the indictments of Letitia James and James Comey. The attorneys general in those cases said there's no case here, and they were fired for doing so, even though they were actually acting in the best interest of their clients, the United States of America, because they were not pushing forward with a case that they knew had no merits. Trump has since tried again, and with Letitia James, a second grand jury refused to indict her. These have been completely unindictable. He's been getting good advice from his lawyers, and what does he do when they give him advice he doesn't like? He fires them. This is beautiful. She is openly putting, this is what we are seeing. This is the ultimate truth to power here. I'm genuinely impressed. Those who safeguard the government, not merely the president, face reprisal in violation of equal protections and due process rights to petition on behalf of all government, not merely one man, should they contest Trump. State attorney generals, ooh, she got that wrong. State attorneys general. That's rare that a lawyer gets that wrong, are overwhelmed by Trump's suits. Lawyers are retaliated against in private firms and extorted for free pro bono for past conflicts with the president's agenda. That was not that long ago. A whole bunch of the legal firms that Trump called out, he pulled their security credentials. He pulled their classified credentials. They could no longer work for the federal government. He barred the federal government from hiring them under any set of circumstances for anybody who's a federal employee. These are D.C. firms. They routinely work for elements of the U.S. government. He made it so they were basically insolvent. They couldn't work, and a number of them capitulated, giving Trump thousands, in one case, I think to the tune of about $4 million worth of free pro bono legal advice. But A, that advice is going to go to Trump personally, and B, that means they can no longer work for any Democrats because there's going to be a conflict of interest. So Trump is eliminating legitimate legal avenues for Democrats to take because he's created a conflict of interest with all the best law firms in D.C. Now, this is not opinion. This is fact. This is not somebody just saying, oh, my God, he's, threatening law firms. We covered this as he was doing it. He wasn't hiding it. He did it well out in the open. MAGA was just saying, well, damn, they should be threatened. No. So, she's got all this dead to rights. I'm in a unique position. I have knowledge that there's a plan to eliminate the judiciary. I'm going to repeat that. I'm in a unique position and have special knowledge that there is a plan to eliminate the judiciary. In 2018, I ran for office because non-lawyers were lawyering, messing up the chain of title and costing the public and private people equitability and monetary harm unrestrained. I learned there was a plan to eliminate judges and eliminate the rule of law that founded, sustains, and maintains the United States as a democratic republic with the passage of the Bill of Rights in December 15, 1791, granting the people the right to petition, coupled with the due process fairness before impartial forums. Again, she's right, but this is where we have a very serious problem, because that includes the people she's talking about, and there's no Supreme Court left that can hear this if she's right, which she is. Okay. The agenda eliminates the Constitution as law to protect freedoms in favor of lawless, unjust, bartered for businesses, allowing only those with power, connections, unjust wealth, or control over resources and access to them, unrestrained from human sacrifice and slavery. Now, we've all suspected something along these lines for a while. I always rule of thumb, when you hear something you like, double check it, because that's when you are most likely to not check the sources and not go back and do due diligence. So she's saying something that sounds right, but as of yet, she has not justified. The judiciary is in danger, I believe. Restoring Article 1. Let's see if, okay. In fact, the other thing we need to do is this document needs to be made available. What I'm going to do is we will put that document. Yeah, that's we're going to put this amicus brief in its entirety. It's 34 pages, and I'm not going to read it all. In fact, actually, let me really quick. Newsweek is the only organization so far that I'm aware of that's covered this. So they may have a synopsis here that could explain it better than I could. Let's see. Delaware attorney Megan Kelly argues that judges at every level, from the trial bench to the Supreme Court, have been facing improper political pressure, raising questions about whether recent landmark rulings and ongoing proceedings can be insulated from threats or retaliation. Her motion, she did submit a motion, but that's misleading. Contends that such pressures could undermine, it's the brief that contends it. Her motion is for the court to accept the brief. Pressures could undermine due process rights for detained immigrants, erode the court's ability to function as neutral arbiters, placing judicial independence at the center of the... Yeah, it does more than that. She's saying that there's a deliberate attempt to eliminate a entire branch of government. She's arguing that they're trying to eliminate the judiciary. I mean, that's a serious... I've heard claims that big before, but never by anyone you could take seriously in a case that was serious. You know, you might have some fly-by-night, car crash attorney, ambulance chaser saying, this is an attack on the entire... No, she means this, and she's already had one of her amicus briefs accepted. Let's see, she attacks Kavanaugh, she attacks Roberts. We already covered some of the Alito. She says that Trump and his allies previously used the threat of treason to kill members of Congress and special counsel Jack Smith. It's not far-fetched that he would use treason or even kill his own lawyers if they sought to do what is right. Yeah, that's coming up in the thing. But I think that's important. And she points out that he's already threatened judges with impeachment for ruling against him. So she's right. I mean, none of this is debatable, with the possible exception, again, of there is a deliberate attempt to wipe out the judiciary. I suspect she's correct, but I have no idea where she's going to get the evidence to support that claim. I seek to preserve issues whether parties can, and I do agree, by the way, as well, if this is allowed to continue, the judiciary isn't going to exist in any functioning sense. They're just going to be a rubber stamp for everything that Trump wants to do, which, by the way, the Supreme Court already is. That's not refutable either. Thus, members judging the case to create a precedent to protect its own members from judgment or punishment. Let's see, that comes from... okay, two cases, Snyder v. Trump, and what's the other one? Trump versus United States. So this is, I think both of these are, okay, you know what? I'm going to need to go back and make sure. I seek to preserve the issue, again, she stated what the issue is, which is due process rights, to whether the parties and the court may restrain even the United States Supreme Court within the purview of the constitutional limits by voiding two decisions based on due process violations. The court in Snyder v. United States removed state and U.S. Attorneys General power to restrain and correct government officials who illicitly partake in bribes under 18 U.S.C. sections 201 and 666 as a violation of due process as applied to this case. The court in Trump v. United States United States, and then let's see, that's 603 U.S. 593, Trump granted Trump a license to commit crimes unrestrained by the Constitution as the law. Okay, so I suspect she's talking, now these are the, these are the Supreme Court decisions that have essentially given Trump unlimited power, and she is now challenging those in district court. Again, it's not that I think she's wrong or shouldn't be doing this, but holy smoke. The problem is, normally what would keep the Supreme Court in check would be the other branches of government, but they're refusing to do that. So she's now basically asking a lower court to overturn the Supreme Court, which he cannot do, in theory. They're not supposed to. I'm curious. I mean, we're common law. I'll have to look into. This is insane. So these should be deemed as void, as apparently described based on the facts showing that the justice's personal stakes unfairly influenced the outcome of these two cases. When members of the U.S. Supreme Court were accused of bribes or bartered for favors in return for verdicts tempting the members to remove the Attorney General's authority to investigate and prosecute the highest court for bribery. Well, this is part of the public record now. And then this is ProPublica. Justice Alito took luxury fishing vacation with GOP billionaire who later, and this is, we've covered this. We know she's right. I mean, it's stunning to hear somebody's, it's really bizarre to be doing these shows and seeing this and wondering if other people, and I imagine, by the way, our audience has some of the same thing. I imagine the reason you're here is because you like what we have to say. And we get into these issues. And all of us have at times been sitting here going like, are we going crazy because we're being gaslit? And by the way, she mentions gaslighting and Trump gaslighting, you know, the courts and the American people into getting him what he wants, which is absolutely true. Let's see. Yes, her, yeah, okay. So let's see. Congressional members, okay, so here she is basically impeaching Congress, the power of the outcome of the U.S. Supreme Court case. Let's see. It's for a petitioner to assert or waive partiality concerns. Yes. Listen, it honestly doesn't matter if somebody's impartial or not. What matters most is, more than anything, usually is the perception. If there's any perception of possible partiality, then they need to leave. But it is the petitioner's right to assert that. And by the way, a little bit of their responsibility too. If you go into court and you're suing somebody, and his wife is the judge, you have the obligation to speak any objections you have to that situation before you get to the end. You can't, after you get to the end and not like it, say, oh, well, she was biased. Yeah, you knew who she was when it started. So it's the petitioner who asserts or waives partiality concerns. And that, instead, in the Supreme Court, the members themselves have been doing it. Thomas has refused to recuse himself in cases where his wife was a defendant. In one case, his wife was a defendant, and nobody knew it because nobody knew how many people had been involved and who those people were. But Thomas knew his wife was, took the case anyway, got it thrown out, and then it turns out his wife would have been a defendant if it had gone to trial. No, nothing wrong there. And there's no recourse. I feel really bad for the DC judge because, first of all, this isn't the same judge who's actually hearing. It's part of the same case, though, because the judge split the cases and sent to, I think Sweeney has this part. They're hearing the criminal contempt motion for Katie Noem is being held by the original judge who was on top of all of this. But whichever judge has it right now, I don't know who they are. But oh my God. And I laugh. I laugh because it I guess laughter is a way of breaking discomfort as well. The reality is, I really hope this gets taken seriously. But if it does, we're going to, real simple. If this is taken as seriously as it should, we are about to hit an extraordinarily difficult and bad time in the United States. And the reason is because the entire judiciary is going to have to come to account for their complicity in the Trump administration and the illegal shenanigans of the Supreme Court of the United States thus far. But better to do it now than when either A, the entire judiciary has collapsed, or B, when the number of crimes everybody has committed has gotten so far that nobody's interested in doing anything about it because everybody's guilty. And that's not a joke. That's how corrupt criminal enterprises, that's how North Korea stays afloat. That's why Kim Jong-un takes his cabinet out for a walk one day and lines up all his political enemies, gives his entire cabinet a gun. Then behind them are a whole bunch of guards, and he says, you shoot that guy. And if his cabinet doesn't shoot his political enemies, members of his cabinet get killed. Why does he do that? A, it increases fear. B, they're now murderers too. And when they say, well, there was literally a gun in my back. If I didn't kill the guy, I'd have to. He just says, no, there wasn't. You just went up and killed him. It was a favor to me. You know, oh, you're guilty too. You're a murderer now. Let's maybe try to stop this before it gets there. But this is going to cause a constitutional crisis either way, because again, she's basically impeaching the entire ability of the U.S. Supreme Court to function, which means if you accept the premise, you've eliminated the central or most powerful recourse, so due process for Trump and his administration. I don't know how you answer that problem. But given the number of constitutional crises we've been faced with in the last year, there's going to be a solution. We can't let the fact that we don't know what it is yet stop us from moving forward. And again, right now, for those of you just joining us, because it's been a while since I've done a rundown on this, this is an amicus brief that has been filed in the case about trying to get Trump to stop deporting people the way he's doing it. There's no problem deporting people under certain circumstances, obviously, but he's just deporting everybody. He's deploying ICE. He's deporting American citizens. He's deporting former soldiers. It's just this haphazard, thing. So there's been a case that's been ongoing about this. It started with the plane loads of prisoners going to El Salvador. This is that same case. They have now gone the class action route because when they enjoined Trump from deporting anybody from any state, the U.S. Supreme Court said, nope, district and state courts can't make federal injunctions, which they've done, not federal, sorry, countrywide injunctions, which they've done before at the federal level. They've done it. There's never, now that it's against Trump, Trump can't deport people, they've got an issue. Fine. So they turned this into a class action suit. We covered that briefly and how and where it stands, but that's what's going on. In that case, an amicus brief, which is a brief by a friend of the court, I think her name's Megyn Kelly, which is irony. Delaware attorney Megyn Kelly has basically said that the entire judiciary at every level has been compromised. It is being pressured, threatened, and unduly influenced by Trump, by the entire executive branch, by the Trump administration, by members in the legislative branch, like House Speaker Mike Johnson, who is in support of Trump and his administration, and by MAGA members who have been threatening judges themselves. We even read one of those threats on air, and she says that this has made it impossible for people to get their constitutional due process rights. It goes all the way up to the Supreme Court. She lists 2 Supreme Court decisions that should on their face be vacated by a lower court. Wow, it takes some cojones. I am impressed. I mean, I'm just genuinely impressed. She has gone over a whole bunch of evidence of these threats. She's gone over evidence of how they have ruled and why these rulings are illegal. She has also said, and this was not mentioned in the Newsweek article, which means either they didn't read the thing or they're ignoring it, that there is a deliberate attempt by this administration to remove the judiciary and or make it irrelevant. I suspect she's right. It may be that Newsweek did not mention it because she does not support that claim, at least that I can see. We went live with this as basically as soon as we had it. I've given this basically a once-over, so, you know, unless I missed something. This is, quite frankly, if this gets accepted, it's huge. Now, keep in mind, and I want to make crystal clear, right now, what I am reading is an amicus brief. The goal of an amicus brief is to sway the judge in one direction or another in a case that you actually aren't a party to. The most famous amicus brief, as I said earlier, The Onion, in amicus of a guy who was doing satire of his police department, and the police department arrested him and jailed him for impersonating a police officer when what he was doing was satire. The Onion, now this got all the way up to the Supreme Court. The Onion has an interest in this. They don't want satire to be made illegal. So even though they weren't a party to the suit, they filed an amicus brief and said, we are filing in amicus of the defendant, meaning we are, it's a friend of the court brief, but we're a friend of the defendant, in amicus of, as a friend of the defendant. And they didn't know the defendant. They just said, look, here's why we're arguing on his side. And they did. And their entire argument was mostly mocking the Supreme Court and then pointing out how by mocking the way they mocked the Supreme Court in the brief itself didn't state we're mocking the court. You cannot, satire doesn't work if you say this is satire. So they submitted a satirical brief and said the only reason this brief is funny is because we didn't say at the beginning this is a satire. It was really ballsy. That was another ballsy one. So that's what an amicus brief is. This is an amicus brief. And she says she is not putting it on either side, for or against the plaintiffs or the defendants, and that it's really an amicus of the court. Having said that, she says that it doesn't help the defendants any, which is putting it mildly. And then goes on to indict everything the Trump administration has done with the judicial branch since he was in office the first term, let alone now. Plaintiffs and potential special counsel. Okay, so this gets into, she's hitting him with, that I can think of, everything that they've done. This includes the deportations, but she mentions essentially Trump's firing of legitimate attorneys general who were giving him advice that was good advice. They were doing their jobs. They were advocating for their states and or the United States of America, and told him, we can't prosecute Comey or Letitia James. He fired them until he found someone who would. So her argument is all of the attorneys on their side are subject now to, you can't trust them because their jobs are at stake, because any amount of political pressure. And he couldn't bring the entire, all he has to do is say, this is a very bad person. I hate this person. I don't like this person. And their house may blow up tomorrow. And he's done that. He's done that with judges. She points that out. U.S. Supreme Court members based on partial interests of the court instead of impartial application of the rule of law. She's already made several indications of where specifically she was going after Alito. I haven't seen her mention Thomas, but he is the most obvious one. But she's once again arguing, look, they're making decisions based on what's best for them, not based on an impartial application of the rule of law, which is fundamentally, constitutionally, what they have to do. So she is... Now, this is already a very large case. It's a very important case. We've all heard about this case. This is the deportations case that's been going on and being fought over, that includes Kristi Noem and her getting the criminal contempt, the airplanes, Garcia, every motion to and from Garcia. Actually, Garcia, I think, was Boston. Garcia may be a different case. But this has been going on. This is the first and continuing case to stop the use of the Alien Enemies Act, and has been before the Supreme Court at least 3 or 4 times on temporary restraining orders, first of the Alien Enemies Act, then of deportation as a special class, and they get shot down every time. One of the interesting things she does here is say every petitioner has the right to get a fair opportunity before an impartial, not a threatened, forum. What's clever about this is something Titan had pointed out. He's right. She's not blaming them. She's not, except for the Supreme Court, possibly. She's not sitting there saying it's the judge's fault or it's the lawyer's fault. She's saying they are being threatened. Everybody has the right to go before a judge who isn't being threatened to rule against you. And this would apply to the judge she's submitting this to. He's been threatened too. This is the one. This is the one who's currently doing the criminal contempt complaint, and the one, it's the same. I forgot his name. It begins with a B. And Trump basically threatened him, and then the Supreme Court kind of said, take it down a notch. Okay, fine, but Trump threatened him. And Trump's in a position to make good on that threat. Trump has made good on that threat with multiple people. So she's talking also about the current sitting judge, which gets us back to the Socrates problem I made at the beginning, which is a difficult position here, because if the judge accepts this into the record, and it's already part of the record, but if he takes this on and then rules in her favor, you're under it could be to show, somebody's going to say, well, is he doing that just to show that he's impartial versus I mean, she is calling into question the very system in which she is participating and submitting a brief in. Again, good for her, but wow, is that a problem. I respectfully request that this court remove threats against judges, justices. Oh, that's all. Okay, that's, yeah, no problem. There's only one way to do that, you realize. That's to impeach Trump and get his ass out of there. And as Commander McMillan likes to point out, Trump is a symptom. He's not the source of the problem. But I respectfully request that this court remove threats against justices and federal judges to protect the rights and fairly petition in this case so as to not compromise the findings of even the U.S. Supreme Court. Preserving facts and issues, government threatening Chief Justice Bosenberg, that's the name. Okay. Let's see. So that's of the appellate court, U.S. Supreme Court, threats of discipline. Yep. Threats of impeachment. All right. Now, is there anything else? Now, I think the rest is just supporting her. I think this is just her supporting the argument. So we don't. Defendants are weaponizing the purse string power and the power of the sword to evade the law, to control the courts, not balance or check branches, which may only be balanced fairly by the petition in an Article 3 form as the sole check on government power, i.e. what she's doing right now. So, now that we've gotten into it, and I apologize for the length, I went on a little longer than intended, but it is, and this may be why they're not covering it in mainstream media, is because this actually requires some thought. I am not a lawyer, so very possible I've missed some important legal thing that makes this completely irrelevant. But from what I can tell, this is a very powerfully put, well put, amicus brief. The judge has an easy out, which is she's made this so unbelievably broad. Now, she brings it back at the end. She's like, okay, and in regards to this case, but you can do this in order to get into the record. So, it's sort of like, if you like, I want to file a complaint. So just one complaint. I have just one complaint. And then you go on a huge list of 300 complaints and how they all tally up to just this one little thing that you want changed. But you've now been heard on all of these things. That's kind of what this is. She's just like, okay, here's how the entire judiciary is collapsing, and this is how it affects us in just this one case, which is the only one that you have any real control over. To which there's some truth, but because we're in a common law system, it's a really good question what the judge is going to do with this. The easiest thing to do is to not accept the brief. He's already accepted an amicus brief from her, which is a good sign in as much as that means the judge thinks she's credible. The judge thinks that amicus briefs don't have to be accepted. They do become part of the record once you've submitted it. So we're reading what she submitted. The judge will decide whether or not he accepts the brief. Even if he accepts the brief, it may not impact his decision. So he may not reference any of it and may say in his final decision, I found the amicus brief unconvincing and there was no element of it that influenced this decision, in which case this is gone. Or he says, the entire U.S. Supreme Court has been compromised, the judiciary is under complete assault, and this brief is correct. A number of decisions need to be overturned, which is a direct assault on the U.S. Supreme Court. They're going to be a little pissed about that, but the question is, what are they going to do? And then if he finds for the plaintiff, the defense is going to appeal, but where are they going to appeal to? It's either the D.C. District Court or the Supreme Court of the United States, which she is now essentially precluding from being able to hear this because they're essentially the complaint. Wow. So that dropped when did that drop? That dropped Wednesday. Took a little while for us to, yeah. So let me check the live chat. And again, apologies. I know it can be dry. I know it but this is a staggering amicus brief. It indicts the entire system, says the entire system is under attack, an opinion with which I very strongly concur. I think she has, evidences most of her claims. The ones that she needs to evidence, she evidences successfully. And it's up to the judge to decide whether or not that, because if the judge himself is not being pressured, or at least believes he's not being pressured, then he doesn't, this amicus brief may have no bearing on the case. The judge is currently trying to find Kristi Noem in criminal contempt, so that would suggest to me that he's been ignoring pressure, if there's been any, so he may find that this has no bearing on him. On the flip side, if he accepts this, any ruling he gives might be invalidated, or it could, but to invalidate it, you'd have to accept her premise as true, which means almost any decision by any court in favor of Donald Trump is potentially invalid. That's really staggering, and I am glad I am not this judge. My hope is he accepts it, but there is a legitimate question of, is it apropos of the case? Because if the judge accepts it, then he's implying that he's been getting undue pressure that could sway him, because her argument is, I don't want that pressure to exist, and this is to combat that pressure. So he would almost be, wow. This is just a wow. Yeah, let's see. He can make matter, he can make money, he can, yeah, she keeps going. All right, we were going to make this available on our Discord. We have a section there for any production materials that we air, so it'll be in the production materials section. It'll be there within a couple of minutes of the closing down of this stream, which, once again, really did take longer than I had anticipated, but we really wanted to. This is a big thing. So, and once again, just as vis-a-vis Trump has pardoned Tina Peters, former Mesa County, Colorado clerk, who was sentenced to 9 years in prison for her role in passing off information to the MyPillow guy in the 2020 election. Donald Trump has pardoned her because he felt that her conviction was unjust, which obviously he feels. The problem is her conviction was in the state of Colorado under Colorado law. He has no jurisdiction there. He cannot pardon that. Only the governor of Colorado can do that. However, in light of the brief that we just heard, the amicus brief about Trump applying pressure and MAGA doing crazy shit, we've already heard reports now of MAGA descending on the prison, demanding her release, contacting the governor, demanding her release, saying she's being held illegally because she's not guilty of any crime, because she's been pardoned. Well, she's been pardoned by the President of the United States for federal crimes. She wasn't convicted of any federal crimes, so, okay, fine. If he wants to waste the magic marker, he can go right ahead and do that. But that's like the President of Germany pardoning her. He's got no jurisdiction. It's a state crime. It was a state judge and a state jury that convicted her. I think MAGA deliberately doesn't care and want to know the difference. They're just, this is where I really hate the cult-like behavior. Who cares what the law is? Who cares what reality is? Trump can't pardon her. She hasn't committed any federal crimes. So we'll see. That's it. Thank you all for joining us. Like I said, find us on the Discord. Please really do like and subscribe and share if you think that we're covering stuff that you're not seeing anywhere else. Share it. A, with people who you think will enjoy it, and B, because it really does help us out. So thank you all for joining us. Our next scheduled show is Tuesday, 9 p.m. Eastern. My guess is we'll make it 12 hours before we're live with something. Have a good night, all.